Despite the Supreme Court's recent ruling, the Department of Justice has now done something to increase the chances that Donald Trump will be tried in the election interference case in Washington, D.C. Let's discuss. I'm Dave Aronberg, State Attorney for Palm Beach County, a.k.a. the Florida Lawman, here on the MeidasTouch Network. I want to thank everyone for your views, your likes, your comments. Please keep them coming. And as far as the Supreme Court's recent decision, I know it upset a lot of us because they threw sand in the gears of justice. The D.C. Circuit Court of Appeals decision was powerful, it was comprehensive, and it was convincing, and it was dealing with an easy issue, the issue of absolute presidential immunity. That's a legal layup. I mean, there's a reason why we left the crown 250 years ago. It's because we didn't want a king, and this absolute immunity garbage would make the president a king. I mean, come on. This is not a hard decision. Yet the Supreme Court stepped in to say, hold on, we want to opine on this. Even though they had a chance to do so back in December, they said, no, let this go through the D.C. Circuit Court of Appeals first. And then they came back and they said, yeah, now let's stay the whole matter while we deliberate on this. And they set an April 22nd oral argument date. But look, don't lose hope. You know, Donald Trump clearly fears the D.C. case the most because that's the case that's most likely of the two federal cases to be heard before the election. The strongest case to me is the Mar-a-Lago documents case, but with Judge Cannon, that's being slow walked. That's not going to be heard before the election, but I still think there's a chance that this case in D.C. can be heard, and something the Department of Justice just did makes it more likely than just a small chance. And clearly they're on this. They realize that this could be their best chance to actually hold Donald Trump accountable. The Department of Justice made an important announcement, and ironically, it was not in the D.C. case, but it affects it. It was actually in the Mar-a-Lago documents case where the Department of Justice told Judge Cannon that its internal policy of not indicting or taking overt investigative steps within 60 days of an election, well, that does not apply to Trump's criminal cases. That's what the DOJ has said. And at this hearing in front of Judge Cannon just recently, Jack Smith's team told the judge that there are no Department of Justice policies that prevent cases that have already been charged from going to trial that close to an election. So it applies even if the defendant is on the ballot himself. So the 60-day rule applies to the grand jury proceedings. It applies to investigative steps. It doesn't apply to someone like Donald Trump, who was already indicted a while ago. So that is the big news, that if this case could get teed up before Judge Chutkan at any time before the election, then it can go. And Judge Chutkan clearly wants it to go. Judge Chutkan has said that she'll cancel her European vacation, which is scheduled for the late summer, early fall, to make this case happen. She wants it to happen. This case was built for speed. Jack Smith wants it to happen. He only indicted on 4 counts. He didn't name any other co-conspirators. The others are unindicted. And so he is targeting Donald Trump in this case. And so there are a few things that could happen that even if the Supreme Court delays and waits until the end of June to come forward with its ruling, which seems like it probably will happen because that's the end of this term for the Supreme Court. So even if the decision comes out at the end of June, here's what could happen. Judge Chutkan has said that Donald Trump has 88 more days to prepare for the case. That's where the case was frozen when Trump took the appeal and there was a stay issued initially by Judge Chutkan. But that 88 days is not set in stone. Judge Chutkan, based on what the Supreme Court did, based on these delays that were not accounted for when Judge Chutkan announced the prep time, the 88 days of prep time, she could limit that. She can cut that. And I think she would. Based on everything that's happened, I think that if this case is decided as late June, that Judge Chutkan will then cut down the 88 days prep time to what? We don't know. But I think it's a likelihood that she would say that, Donald Trump, you had so much time already to prepare. You don't need another 88 days on top of that. So let's get moving. Plus, Jack Smith could also speed up his own case. Jack Smith has said his case could take a couple months. But I think that knowing that there's an election around the corner, he either speeds up his case or he may even cut down on the charges. Right now there are 4 counts. He could cut it down to 2 if he wanted to. I don't think he needs to. I think he could speed up his case without having to cut the number of counts. But these are options that are available to a judge who wants this thing to go and a lead prosecutor who wants this thing to go. Now, one concern I have is that the Supreme Court would not only wait until the end of June to announce its ruling, but then they also could remand the case to the district court, Judge Chutkan, and say, here's our new rule on presidential immunity. Instead of just saying there is no presidential immunity in this case, we're going to say it could be available in certain cases, and it's up to you, Judge Chutkan, to make the factual finding whether it applies here. So worst case scenario, that could push this case even closer to the election or even past the election. But even if it does push it closer to the election by delaying it even further, a conservative commentator, George Conway, an ever-Trumper, has said that that would still hurt Trump because then the trial would be taking place so close to the election that it would wound Trump politically more than if it took place a lot sooner. Here's what Conway said.
Yeah, politically, I don't think it's helpful for Donald Trump. I mean, sometimes in litigation, you lose by getting what you asked for, and what he has asked for in the January 6th case is delay, but he may not get enough delay. I mean, the Supreme Court took this case and probably for good, not to delay the case, but I think they probably think they have something to add to the law in this area, and there are multiple motions that Donald Trump has been making, both in Georgia and in Florida, that maybe the guidance could be helpful from the Supreme Court. But the end result would be we're going to get a decision that the case is still expedited. The appeal to the Supreme Court is still expedited. We're going to get a decision by the end of June, maybe even earlier. And if that's true, and you do the math, you get a trial in August, September, or October. And that is not a good thing for Donald Trump. It would be better to get the thing over with, frankly, even with a conviction.
So that is another possibility. We don't know exactly what's going to happen, but my point is Meidas Mighty, don't lose hope. Even if the Supreme Court pushes this past the election, there is still reason to believe that Trump will be held accountable, at least in part. And that is because there is definitely one trial that will be taking place before the election. That's the case in New York, the Stormy Daniels hush money payments trial. That's the case where Alvin Bragg, the DA, is arguing that because Donald Trump falsified business records, he was able to hide payments to a porn star that would have damaged his election chances. Thus, it's a campaign finance violation. Thus, it's election interference. And thus, these are felonies, and he should be sent to prison. This is what Alvin Bragg will be arguing. And whether you think it's the strongest case or not, I think it's probably the 4th out of 4 of the criminal cases against Trump. It is not necessarily a weak case. It is a case that will dominate the headlines. And in front of Trump's evangelical base, they're going to have to deal with the fact that he made these payments to an adult film star. And then, if he's found guilty, there is a number of the voters of the population who say they will not vote for Donald Trump if he is guilty of any of these charges against him. So whether that holds true, we shall see. But for those who believe that Donald Trump will be immune from any convictions, any prosecutions before the election, no, there's at least one case that is going to be heard, the one in New York, and that case is pardon-proof. Trump cannot pardon himself out of it. But also, there is a real possibility that despite the Supreme Court's intervention, that the D.C. election interference case will happen. And if it does happen, it's going to happen close to the election because the Department of Justice says that even if it's close to the election, it's still game on. So stay tuned. Thank you so much for watching. I hope you enjoyed this video. If you liked it, please like it and subscribe. I'm Dave Aronberg, a.k.a. the Florida Lawman. See you next time.
Hey, Meidas Mighty, love this report? Continue the conversation by following us on Instagram @MeidasTouch to keep up with the most important news of the day. What are you waiting for? Follow us now.